After a 4-day adjournment, the Senate President returned to the Code of Conduct Tribunal to continue his trial for alleged falsification of assets. At the beginning of the proceedings, the chairman of the tribunal, Mr. Elladi Umar, dismissed allegations of bias made against him in the trial. According to him, the allegations of bias are untrue and unfounded. He recalled that during the trial of the former Lagos State Governor, Senator Bola Ahmed Tinubu, the tribunal was under pressure to convict him, but the tribunal did the right thing. He swore that in this particular case, the tribunal would do justice without fear or favor. Umar also reacted to the number of counsels representing Dr. Saraki in the trial. According to him, the records of the tribunal showed that there are about 100 counsels standing for the defendant, and in order to ensure orderliness in the proceedings and records of the court, all the other lawyers can assist the lead counsel to the defendant, Chief Kanu Agabi, rather than each lawyer in the defense team doing the job. But the other member of the tribunal, Atanza Willand, said that the issue of representation had been settled and that an accused person is entitled to as many lawyers as he wants. According to him, the chairman's remark was only to ensure that there was order in the court. He was also concerned that there are insinuations that he was not contributing enough to the process. Mr. Atanze says he might have his differences, but will rather sort it out in the chambers rather than in the public glare. While counsel to Saraki in his response says that everyone who comes before the court of law must be concerned about prejudice, the prosecutor, Rotimi Jacobs, noted that every court has a duty to regulate its own court and that the fear of prejudice by the defendant is unfounded. As the issue died down, the tribunal continued with the cross-examination of the first prosecution witness, Mr. Michael Wetkas, who admitted before the tribunal that there was no document before the tribunal linking the Senate President with the ownership of the Ikoyi property. He was quick to add that the Senate President had declared the said property in his asset declaration. That is why the AFCC linked him to it. While the prosecutor insists that the cross-examination is a delay tactic, Saraki's lawyers say it has been an opportunity to bring out the flaw in the charges.
One would not expect one witness to be cross-examined for 9 days, and then you are still adjourning for the next day, for other days. So we are complaining that the defense should sit up.
I think any fair-minded Nigerian would agree that it is only right that the person should have the time and he should be able to cross-examine the witness in regard to those things that they have said. And that is exactly what we are doing.
After a 3-day recess, the tribunal returned to continue the cross-examination of the chief prosecution witness. And after 4 hours of being grilled, the tribunal adjourned again to continue his cross-examination on the 18th of May 2016. Amaka Okafor, Channels Television News.